Welcome back to Criminal Law, everyone, and to a special review lecture in our Elements of Liability module. In this recording, I'm going to try to provide you with a big picture overview of the 5 elements of liability we've covered in this module. My reason for doing this, and for providing this review, isn't to revisit every topic we've covered in this module, or to summarize all the material you might be tested on. Instead, my central goal is to explain to you how the elements of liability can and should be used to analyze fact patterns. Because as we'll see, the joint application of these elements is more or less what's necessary to determine whether criminal liability exists in individual cases. That's true in the real world of criminal practice, but particularly so on the exam, where you can expect the following to happen. First, you're going to be presented with fact patterns involving bad behavior in criminal statutes, which potentially cover the behavior of an actor. And then second, you're going to be asked to apply those statutes to that actor's behavior. Sometimes you'll be asked to analyze these statutes from the perspective of a prosecutor. Other times you'll be asked to analyze statutes from the perspective of a defense attorney. But in either case, the central question you'll need to figure out is whether someone can be convicted for violating those statutes. And to provide that answer, you'll need to methodically assess whether each of the 5 elements of liability can be met. That is, unless I tell you otherwise. So look, there's no inherently right or wrong way to assess whether all 5 elements of liability can be met. But I do think that there are easier and more intuitive ways to conduct this kind of multi-step analysis. And so that's what I'm going to present you with now, while also briefly reviewing the 5 elements of liability we've covered in this module. Okay, so you're presented with a fact pattern involving someone's harmful conduct, a criminal offense codified by a statute, and a question prompt which asks you to determine whether the actor can be convicted for committing a criminal offense. What's the first thing you should do? Well, the first thing you should do is probably take a deep breath, followed by a long exhale, and then recognize that you are smart, you are capable, and that you have what it takes to answer this question. But in terms of your analysis, the first thing you should do is look at the facts and law you've been presented with, and then assess whether the defendant engaged in a voluntary act or omission. Because it's just about always going to make sense to start your liability analysis with the voluntary act requirement. To do that, you'll want to look for proof that the defendant engaged in a voluntary act, understood in terms of a bodily movement, which is the product of conscious effort and determination. Or, barring the presence of a voluntary act, you want to look for the existence of a voluntary omission, understood in terms of the failure to act in the face of a legal duty under circumstances where the person was physically capable of fulfilling that duty. Here's a question for you. How do you know that this voluntary act analysis is always required? It's not because of the call of a criminal offense. Take a look at an offense definition, and you're going to find that it doesn't expressly state the need to prove a voluntary act or omission. Instead, the requirement of a voluntary act is a general background principle that simply exists in all prosecutions. That principle is rooted in the common law, as we saw in the Martin case. And it's also expressly codified by the Model Penal Code in its general part, which we studied in section 2.01. That's why the requirement of a voluntary act or omission applies to all criminal prosecutions, even if individual offenses say nothing about it. And it's also why you always need to analyze it to determine the existence of criminal liability for any offense. And because the requirement of a voluntary act or omission is usually the simplest and most basic component of criminal liability, I recommend you analyze it first. Okay, so once you've analyzed whether the voluntary act requirement is met, the next element of liability I recommend you address is social harm. But what's social harm? Well, for purposes of this class, social harm is nothing more than the behavior prohibited by an offense, which is articulated through the objective elements of an offense. The objective elements of an offense supply the rule of conduct. That is, they describe what you're not supposed to do, or on occasion, what you have to do. And they're also basically what's left after you subtract out any mens rea terminology. So in this class, we've studied 3 kinds of objective elements: result elements, circumstance elements, and nature of the conduct elements. As we've discussed, the social harm of every offense includes either a result element or a nature of the conduct element, and then one or more circumstance elements which modify the result element or nature of the conduct element. So for example, an APO offense, which prohibits purposely causing bodily injury to a police officer, involves the social harm of injuring a police officer. This social harm is expressed through 2 objective elements: the result element of bodily injury and the circumstance element of the victim being a police officer. Along similar lines, a joyriding offense, which prohibits knowingly using the motor vehicle of another without consent, involves the social harm of using another person's motor vehicle without consent. That social harm is expressed through three objective elements: using, which is a nature of the conduct element; the fact that the thing used be a motor vehicle, which is a circumstance element; and the fact that the use occur without consent, which is also a circumstance element. The basic idea behind social harm analysis is simple. Whatever the objective elements of an offense state, the government has to prove beyond a reasonable doubt to secure conviction. Simply put, there's no murder without proof of death, there's no joyriding without proof that a car was used, and there's no assault of a police officer without proof that the victim was a police officer. So whenever you're asked to analyze criminal liability, you're going to need to analyze social harm by identifying the objective elements of the charged offense and assessing whether they can be established beyond a reasonable doubt based on the facts you're presented with. Note that there's no model penal code or common law approach to social harm analysis. It's just a straightforward application of the objective elements in an offense definition to the facts of a case. Are you with me so far out there? I hope so. Okay, so the first two steps of the elements of liability analysis focuses on the voluntary act and social harm. The third and next step is to assess causation, which, as you've recently learned, is the requirement of a close connection between the voluntary act and social harm. But as you've also learned, that connection only needs to be proven in situations where the social harm of an offense involves a result element. So, as a threshold matter, you're going to want to check to see whether the charged offense incorporates any result elements. If not, well, then you can skip this step. Where, by contrast, a charged offense does incorporate a result element, then causation becomes a required element of criminal liability, in just the same way as the requirements of a voluntary act or social harm. This means that someone can't be convicted of a result element crime unless it can be proven beyond a reasonable doubt that their conduct caused a prohibited result. There are two different components of causation: factual causation and legal causation. Simply put, factual causation requires proof that the result would not have occurred when it did, but for the person's conduct. This is essentially a scientific inquiry, which asks you to imagine a world in which the defendant's conduct did not occur. And it's also in contrast to the fundamentally moral inquiry required by legal causation, which is also an essential component of every result element crime. For purposes of this class, there are two aspects of legal causation which must be proven. First, and most fundamentally, it has to be proven that the result was reasonably foreseeable in its manner of occurrence, based on the rules of responsive and coincidental intervening causes we discussed in class. Second, it must also be proven that the result factually caused by the defendant was not too dependent upon the free, deliberate, and informed conduct of another person to fairly hold the defendant responsible for it. Okay, so here's a question. How do you know that this analysis is required? Well, sometimes a criminal offense might hint at it because of how it's drafted. So, for example, some result element crimes will explicitly incorporate the term causes before the result element. For instance, one common definition of murder prohibits purposely causing the death of another person. But just as often, a result element crime may omit any mention of the term causes before the result element. So, for example, murder might also be defined as just purposely killing another person. But regardless of how an offense is drafted, causation always has to be proven for result element crimes because factual and legal causation, like the voluntary act requirement, are background principles of criminal liability. Now, doctrinally, there are both common law and MPC approaches to these principles. But realistically, this is an area where the common law reigns supreme, and the MPC approaches had little influence because of how confusing it is. As a result, all the causation principles we studied in this class, and the principles you'll be responsible for on the exam, come from the common law. Okay, so at this point, we've now discussed three elements of criminal liability: the voluntary act, social harm, and causation. These elements comprise what's often referred to as an offense's actus reus, which is essentially the physical component of an offense, or what in Latin means the evil-doing hand. When determining whether criminal liability exists, the first thing you'll want to do is figure out whether the actus reus of an offense can be proven beyond a reasonable doubt. From there, you'll want to ask the same question about the offense's mens rea, or evil-doing mind, which is the fourth element of liability to be analyzed after you've analyzed the voluntary act, social harm, and causation. So we've learned a lot about mens rea so far, but tying everything together, there are, I think, three main components of a mens rea analysis. The first component is a determination of what culpable mental state, if any, applies to each objective element of an offense. To do that, you divide up the social harm of an offense into individual objective elements, that is, results, circumstances, and nature of the conduct elements. Then you would try to assess which culpable mental state, if any, the legislature intended to apply to each of these objective elements. In a jurisdiction that's adopted the model penal code approach to mens rea, this inquiry is usually pretty straightforward because the legislature has codified its intent through two interpretive rules. The first rule is the MPC's travel forward rule, which typically requires that you distribute a mens rea term to everything that follows it. The second rule is the MPC's default rule, which requires that you read in recklessness in situations of uncertainty. So these two rules codify legislative intent, but note that it's always legislative intent that reigns supreme. So for example, if a legislature uses a phrase like in fact, as in no person shall purposely cause bodily injury to someone who is in fact a police officer, well then we know that the legislature intended strict liability. And so strict liability is what must be applied. Okay, so that's the MPC approach to interpreting mens rea. But what about jurisdictions that haven't adopted it? Well, in that case, things are a bit messier. If you're presented with a statute silent on mens rea in this kind of jurisdiction, you'll need to figure out whether the presumption of mens rea we learned about in the Morissette case applies. The general idea here is that the legislature intends for some mens rea to apply to all offenses, with the exception of morality crimes and public welfare crimes, which historically have been subject to strict liability. So in that case, you'll need to assess whether the charged offense falls into one of these two categories based on the four-factor test we learned. If that four-factor test indicates that you're dealing with a public welfare offense, then the presumption of mens rea does not apply because the legislature likely intended to impose strict liability. By contrast, if an offense silent on mens rea is not a morality or public welfare crime, then the presumption of mens rea does apply. In that case, we read in the common law mental state of malice, which is the equivalent to MPC recklessness, as the common law default. But please note, in performing this analysis, you may also find it helpful to draw on the 3 steps to success methodology for identifying legislative intent that we've been practicing throughout the semester. Okay, so identifying the culpable mental states that apply to a statute is the first and most difficult component of mens rea analysis. The second and next component is straightforward. You plug in the definitions of mens rea terms and you apply them to the objective elements of an offense to determine an element-by-element statement of the government's burden of proof. In a jurisdiction that's adopted the MPC approach to mens rea, this requires identifying the kind of objective element to which a culpable mental state applies. But why? Well, that's because the MPC definitions of purpose and knowledge differ depending upon whether they apply to a result, circumstance, or nature of the conduct element. Now, please keep in mind that for purposes of this class, you only need to be able to differentiate between result elements and circumstance elements. I'm going to identify any nature of the conduct elements for you on the exam. Now, by contrast, in a jurisdiction that hasn't adopted the MPC approach to mens rea, you don't need to worry too much about categorizing objective elements because the definitions of common law mental states don't vary between them. However, that's also going to be clear to you because I'll write out statutory definitions of any common law mens rea terms I'm going to ask you to apply. Okay, so the third and final component of mens rea analysis is also straightforward. You need to apply the element-by-element statement of the government's burden of proof that you generated in step 2 to the facts you've been presented with and determine whether the government can meet its burden. So in real life, generating proof of mens rea can be complicated. But in the world of law school exams, things are usually a lot simpler because you're typically told what was happening in the defendant's mind. The only real complication here is that sometimes the criminal law will impute a mental state that doesn't strictly exist as a factual matter based upon proof that other conditions are met. So in this class, there are 2 types of conditions we focused on. The first is the common law approach to willful blindness, which imputes knowledge based on purposeful avoidance. The second set of conditions is the MPC approach to voluntary intoxication, which imputes recklessness under circumstances where a person who is unaware of a risk because of their voluntarily intoxicated state. Alternatively, in a jurisdiction that applies the common law approach to voluntary intoxication, there's no recklessness imputation, but rather a restriction on the presentation of intoxication evidence to negate mens rea in prosecutions for general intent crimes. Here's another thing to note. For fact patterns raising mistake or ignorance, the application of a logical corollary approach will usually take care of things and provide you with the right answer. But there are very limited situations in which mistake or ignorance as to the criminality of someone's conduct, which doesn't negate offense elements, but can still excuse based on the narrow fair notice and reasonable reliance principles we discussed. Okay, so if you can keep all that in mind, well then you should be good to go. And you'll also have completed the 4 most important steps in the elements of liability analysis. So where that analysis suggests that both actus reus and mens rea can be proven beyond a reasonable doubt, it's very likely that criminal liability exists, but it's not guaranteed. Why? Well, because there's a 5th and final element of liability that exists in criminal cases, and that's concurrence. As we learned, concurrence is the requirement that mens rea and actus reus be simultaneous or occur alongside one another. As a result, it has to be proven that the defendant possessed the mens rea of an offense at the time he or she engaged in the voluntary act or omission which caused the social harm prohibited by an offense. By contrast, where someone possesses the mens rea of an offense either before or after the commission of the voluntary conduct, but not during its perpetration, well then the concurrence requirement would not be met, and so criminal liability would be barred. As we discussed, situations in which concurrence is lacking are likely to be pretty rare, and so when those situations arise, they're likely to be pretty obvious. Nevertheless, it is something you need to keep an eye on. And so that is your elements of liability analysis. There's more to be said about exam writing and exam taking with this framework, which we'll cover more in our review class. But for now, you have what you need to begin working through the practice exam question that I provided you with. I'll look forward to discussing that and the elements of liability analysis during our next class. With that, take care, and I'll see you soon.